Hello everyone. Let us see another landmark of the Supreme Court, and that is Mithu versus State of Punjab. This case has examined the constitutional validity of section 303 of the IPC. 303 of the Indian Penal Codes provide for the punishment, and that to be mandatory death punishment is given to life convict. It means section 303 is the provision which gives mandatory death sentence to a person who is undergoing the sentence of life imprisonment, and while undergoing life imprisonment, if such person is murdering someone, then he is awarded with death sentence, and rather it is mandatory death sentence ka situation. It means no other punishment is there in the alternative, as the word shall is given. So Supreme Court have examined, is it constitutional? Because if we see other offences, be it murder, which is punishable under IPC under section 302, it makes death sentence as the alternative punishment. Along with death sentence, it is life imprisonment and fine. तो क्या केवल death sentence रखना as a form of punishment, that to a person who is life convict, isn't not the violation of his fundamental right, and that to be Article 14 and Article 21. So what is the case? Let us see the detail of this case. So name of this case is Mithu versus State of Punjab, which was decided on 7th April 1983, and the citation of this case is 1983 Supreme Court. It was decided by 5-judge bench comprising following justices. It was Justice Y.V. Chandrachud, along with him Sayyid Murtaza Fazal Ali was there, Justice Tulja Purkar, along with him O. Chinnappa Reddy Justice was there, and A. Vardarajan Justice was also there. So this was the 5-judge constitutional bench which have examined the constitutional validity of section 303 of the IPC. अगर हम अपना नया लॉ देखेंगे BNS, that is भारतीय न्याय संहिता, so that irregularity has been already removed under the new law. So let me tell you that how that new law has already taken care of that irregularity, and what stand our Supreme Court have taken through this 5-judge bench. हुआ क्या था? Along with that Mithu and one another person, they were in prison and they were undergoing the sentence of imprisonment for life. It means they are already the convicted person and they have been sentenced with the life imprisonment as the form of punishment, and being inside the prison they have murder, यानी prison में रहते हुए they have committed the offense of murder. It means section 303 of the IPC was invoked. Section 303 of the IPC talks about such situation जहां पर जेल में रहते हुए if a convict is there and that convict is undergoing his sentence of life imprisonment, and while undergoing such sentence of life imprisonment, if he commits the offense of murder, then he shall be punished with the punishment of death sentence. Let me tell you what is given in 303 of the IPC, which was challenged in this case. Section 303 of the IPC talks about such situation where the convict person is there and this convicted person is undergoing his sentence, and that to be the sentence of life imprisonment, and while being in prison, when he is undergoing his sentence of life imprisonment, he has committed the offense of murder. अगर ऐसे केस में जहां पे एक convicted person है जिसे life imprisonment की सजा मिली हुई है and he is undergoing such sentence, and if he commits the offense of murder, then in that situation he shall be mandatory given the sentence of death. It means he shall be punished with death sentence. तो ऐसा इंसान जो जेल में अपनी लाइफ इम्प्रिजमेंट अंडरगो कर रहा है, एंड इन दैट स्टेज इफ ही मर्डर समबडी, देन there is only one punishment, and that to be compulsory, mandatory hai. Shall word is written in the Ware Act. It means court also have the no judicial wisdom in this case. That's why this Mithu and that another person, they have first gone to the Punjab and Haryana High Court, jahan par their conviction was upheld. Then ultimately they went to the Supreme Court, and Supreme Court has examined the constitutional validity of this provision 303 and has laid down that this provision is unconstitutional because it is violative of Article 14 of the Constitution of India. Along with Article 14, it is also violative of Article 21 of the Constitution of India. So let us see how this section 303, जो कि अब BNS में, भारतीय न्याय संहिता में, that is given in 104, but new law में that irregularity has been addressed. So let us see how this section 303 of the IPC is violative of Article 14 and Article 21 of the Constitution of India. We all know that Article 14 talks about right to equality. In case of other offences, wherever death sentence is one of the form of punishment, other alternative form of sentence is also there. तो ऐसा जो भी offences है जहां पर death sentence is one of the form of punishment, we find that some other alternative punishment is there, be it life imprisonment or something else. लेकिन यहाँ पर there is only one punishment, and that is death sentence. Isn't we are discriminating one class of prisoners and we are giving harsher punishment to them, and that rational classification is not based, that is rather irrational classification, that is not based on any justifiable or classification. तो यहाँ पर we are violating Article 14 of the convict. एक तरफ तो other accused, they have the options of other punishment, and court is there. It is the court who ultimately decides the punishment depending on the nature of the offense, and the nature of the offender is also taken into account. But in this case, judicial wisdom is also taken, because the section says that shall be punished with death, यानी judicial discretion भी नहीं है इस केस में. Moreover, that life convict का Article 14 is being violated. And how his Article 14 is being violated? Because we are discriminating a class of prisoners and we are imposing them harsher punishment. और harsher punishment देने का there is no reasonable classification. It means outrightly Article 14 is being violated. Mere ground that they are undergoing life imprisonment, and during that sentence they have committed the offense of murder. No other option is there when it comes to their sentence. So it is violative of their Article 14. Along with Article 14, the Article 21 of the Constitution is also being violated of the accused. How Article 21, which talks about right to life, is being violated? Because none of the fundamental right is absolute. Same is the case of Article 21 also. It could be taken, but by the procedure established by law. Where is that due procedure? Because mandatory death sentence, without considering any of the circumstance, be it mitigating situation, be it is the case of mitigating situation, क्या ये just classification है? Whether this procedure is fair and reasonable? Answer is outrightly no. Because if we are giving mandatory death sentence बिना consider किए हुए circumstance of that particular case, without considering the mitigating circumstance, it is not the just, fair, or reasonable procedure. It means, again, it is the case of violation of Article 21, because right to life can be taken, but that to be, if that is done by the procedure established by law. लेकिन जब हम कोई circumstance को consider कर ही नहीं रहे हैं, as we know that death sentence is constitutional. We have already seen the Bachchan Singh ka case, but the Supreme Court has held that it should be awarded in the rarest of the rare case, examining all the circumstance of that particular case, be it mitigating situation or the aggravating situation. But mandatory death sentence does not give any scope of considering any circumstance, be it mitigating circumstance. It means Article 21 is also violated. So 303 of the IPC, which talks about death sentence to be the form of punishment, has many flaws. On one hand, it is taking the judicial discretion, क्योंकि कोर्ट के पास कोई ऑप्शन ही नहीं है. Judicial wisdom is being taken by giving mandatory death sentence. Moreover, on the other hand, accused की fundamental right is being violated. Mere fact that is a life convict undergoing life sentence and he commits murder, he shall be awarded death sentence, whereas for the other offenders who have committed murder, it is alternative punishment. तो या तो death sentence मिल सकती है or the life imprisonment and fine, but there is no scope with respect to life convict. So ultimately, our Supreme Court, through this judgment of Mithu versus State of Punjab, has held that Section 303 of the IPC is unconstitutional. And how it is unconstitutional? Because it is violative of Article 14 and Article 21 of the Constitution of India. क्योंकि यहाँ पर discrimination is done between the class of prisoners and that discrimination is without any reasonable classification. Moreover, life is being taken and that to be without the following the due procedure established by law. So, as it is violative of Article 14 and Article 21, moreover, there is no judicial wisdom when we talk about mandatory death sentence. Hence, the court have held through this judgment that Section 303 of the IPC is unconstitutional. But if we see our new law, so that problem has been addressed. 303 is now being given under Section 104 of the Bharatiya Nyaya Sanhita. And here, if the same situation is there, कि अगर कोई convict है and that convict person is undergoing his sentence of life imprisonment, and while undergoing life imprisonment, if he murders somebody, then he could be either punished with death sentence or with life imprisonment. It means alternative punishment is given. Mandatory death sentence हमने नहीं रखा है, as it was in case of 303 of the IPC. So that problem has been already taken care under 104 of the IPC, and this judgment has laid down that 303 of the IPC is unconstitutional because it takes the fundamental right of the life convict as well as the judicial wisdom is being taken, because whatever punishment is there for the offense of murder, that is being given under 303 of the 302 of the IPC. 300 defines the offense of murder and 302 talks about the punishment of murder. तो मर्डर के पनिशमेंट के लिए वी हैव ऑल्टरनेटिव sentences, death sentence or life imprisonment and fine. So through this judgment, court has said that whatever will be the case of murder, be it by life convict inside the prison, that will be only covered under 302. It means he could be even awarded life imprisonment, or if the court seems just, it could be death sentence. लेकिन mandatory sentence is not there. Discretion is being given through this judgment. So this judgment plays an important role when it comes to imposing death sentence as the only form of punishment as per the provision of 303 to the life convict, which has been held unconstitutional in this case. Now it's the time for your practice question. Let us see what question you have in prelims. You have to tell that out of these three statements, which are the statements are correct. So you have to consider following statement and you have to tell that with respect to the case of Mithu versus State of Punjab, whose citation is 1983 Supreme Court. The consent statement is true. Is it 1, 2, 3, all, or the combinations of these statements? The first statement is whether in this case Supreme Court has upheld the constitutional validity of section 303 of the IPC, which provides for mandatory death sentence to the life convict who is undergoing his sentence of life imprisonment, and if he murders, it is the case of mandatory death sentence. So kya through this judgment court has upheld the constitutional validity, or this ruling emphasized that mandatory death sentence is the violative of Article 21 right to life, or the statement 3 that this judgment reinforced that there is a need of judicial discretion to be given when it comes to awarding punishment. So which of these three or all of these three or the combinations of these statement is true, that you have to tell. Let us see what question you have in mains. You have to examine this decision of Supreme Court in Mithu versus State of Punjab, how this court have taken this stand that this section 303 is unconstitutional of the IPC. So you have to write that what is the significance of this ruling with respect to the context of judicial discretion and right to life. On what grounds the court have declared this 303 to be unconstitutional, what implication it has on the subsequent ruling when it comes to judicial discretion and right to life, which is being taken as a ground to declare it unconstitutional. Thank you.